Pam?
For the record, again, my name is Phil Luetkehans. I'm an attorney representing a number of Dewitt County residents. My goal here is to, for the most part, summarize what you've heard today, put it in this last 8 days, put it in context, mostly in the context of your ordinance, the LaSalle factors, which are your standards 1 through 6 for approving a special use. Before I do, I really want to thank all of you for your time. I know this is a burden that I don't know if you get paid for, but if you do, it sure as heck ain't enough. I also want to thank both sides of this room for their participation, because it's only through that participation, and I mean that on both sides of this issue, that we learn facts, we learn what really are the issues, and we test the statements that each side are making. And that's really what you're here to do, is test those statements. Mr. Griffin did a very nice job at the beginning. He started off with laying out the 6 standards. And when he goes through those standards, it seems pretty simple. We meet them. Here's how we meet 1, here's how we meet 2, here's how we meet 3, 4, 5, 6. But it's not just what Mr. Griffin says. They have to actually prove that they meet all of those 6 standards, and that they prove that they meet all of the rest of your zoning ordinance. And that word's very important, prove. It is their burden of proof. These objectors don't have to prove anything. Not one thing. The burden is on Tradewinds to prove all 6 of those standards and every other part of your ordinance is met. They haven't done that, and they can't. And we'll walk through how they failed. First, as you've heard a number of times, and I'm just going to kind of summarize these, and please don't hold me to the exact words because I don't want to bore you with them. But health, safety, and welfare, right? I mean, that's really standard number 1 in a nutshell. Mr. Griffin started out with those, which he should, and he came up with points of what he was relying on to say they meet the health, safety, and welfare standard. Let's test those statements with what we've heard in the last 8 minutes. First of all, what was number 1? We're going to give you tax revenue. That's going to help the health, safety, and welfare of this county. There's a little problem with that. And I mentioned it the first when Mr. Loomis testified. Before you is SLG Exhibit 22. I apologize, I didn't hand it to you in order, but of the 3 I gave you, it's the last one. If you go to page 5, and you go to there's a head note that says 6 on the bottom right-hand corner. And this is the appellate court talking about this exact argument. You're going to get more taxes, so you should allow us to build. Halfway through that number 6, it says, the argument that rezoning would increase the tax base as opposed to conserving the tax base has been rejected. Such a justification is totally illusory and totally violated. I don't even know how to say that word. Violative of all the basic principles of zoning. It is absolutely irrelevant, and to rely on it is nothing more than complete disregard of the law. And for them to rely on it is also disregard of the law. Why is that? Nowhere in health, safety, and welfare does it talk about tax benefits. Nowhere does it talk about jobs. That's also been rejected. That's what they're trying to rely on. That's 1 and 2. They're trying to buy zoning. The courts have said, you can't. It's absolutely illegal. I know none of you are deciding on this basis, and I know to the county board members it may be an issue, but I'm here to tell them, and I think you need to tell them as well, that that is wrong. They cannot just kind of forget about their responsibility to the county because of the money. Create jobs, that was number 2. Again, that's not mentioned in Standard 1, health, safety, and welfare anywhere. In fact, the case law, someone tried to propose that, and the case law is like, no, no, no. Doesn't work. Further, we have no idea how many of these jobs will actually be Dewitt County residents, or if the money will be spent here and come back to the community. We don't know. Loomis didn't know. He had no idea. None. They say it will improve the general welfare of the community. How? They relied on the 2 items that are not part of the standards, but Tradewinds, which is work, jobs, and taxes. Their 2 main arguments are based on items that are not in the standard they are trying to make. They said they exceed the sound setback levels, and we'll talk about that in a little more detail, but they have no choice. The setback is 2,000 feet. Of course, 80% of the homes in the area exceed the setback levels. It's a physical impossibility not to exceed the setback levels. Same thing with sound. It's the question of those right at the edge, especially as it relates to sound. Those people we heard who are 2,000 feet away, 21 feet away, 2,100 feet away. Those are the people we need to protect. What's really interesting to me and it kind of occurred the first night, it was kind of walked through real quickly. No one really discussed it because Ms. Sarver was doing her job and telling you what you hadn't received, right? We hadn't received the setback waivers, we haven't received this waiver, we haven't received this lease. What no one ever told us is which of those properties were affected. We don't know. Tradewind said, we're not giving them to you, but we don't know what they're affected. It's an absolute joke. They're hiding the ball here and everywhere else. So what we have here, and you saw this, I think, in Ms. Shiflett's testimony, we provided that. You have 5 different homes, all labeled here, and I won't bother you with them, but it's here, it's in the record, you can have these, that you're waiting for. You never heard. We're going to maybe get them in the future? That's not what you have in front of you. You can't rely on that. And then we have 2 places in here that say pending leases. We haven't seen the leases. They haven't been filed. They haven't been, I don't know where they are. don't know which turbines that they have to take out because of that. We know they do, but they haven't told us which ones are no longer here. We hear, oh, we've asked for 71, but we only want 67. Which ones? Which ones? This is the information you should have gotten from the applicant. Instead, we had to give it to you. I'll move that. I apologize. I just realized that it's right in the way. Sorry. That's not our job. It's not your job. They're asking you to do their job. They're asking us to do their job. Because they're hoping that these people aren't going to take the time and find it out that they can tell you. This application was premature. You're going to hear that a lot from me in the next half hour, 45 minutes. And I apologize it's going to take that long, but we've had a lot of testimony. It was premature. They didn't do their homework. They expected everybody else to do it for them or just pretend they did it. As to sound, let's again test what they're saying. Let's test. That's why we cross-examine. That's why we've seen some of this testimony. They're saying they're not actually exceeding sound levels, but they're right at the edge. In reality, they're over the Illinois Pollution Control Board regulations and much higher than recommended by a plethora of experts. Let's start with the IPCB regulations. Mr. O'Neill admitted that they were actually over 41.0. But guess what? We round down. That's what we do in this industry. We round down. It doesn't say you can be at a 41.5. It says we can be at 41. We know their measurement goes to the 10th place. He admitted it. However, because we were able to ask the question, we know some of these sound levels are up at 41.5 dB at 41. The hertz level at 1,000 hertz. The maximum is 41. We know some of them are at 41.5. They've admitted that they violate the IPCB regulations under their own models. They've admitted it. The reason they didn't give it to you in the first place to the 10th is because they knew it would be a major problem for them. So again, they did not provide you the full modeling results. Let me give you for a second a little of my background. I've been doing zoning for 30 years. Started in the DuPage County State's Attorney's Office, been doing it on behalf of private clients, the public, for those 30 years. About 4 years ago, I was asked to do a wind turbine case. First one. Like a lot of people in the room, you know, I see them driving down I-55 or I-65. It's kind of cool. I got into it. And I may have some different feelings now, but those are the. What's relevant is that first case. That's where I met Mr. Griffin. And it was Venergy was filing the application. I was representing the property owners in the area. And Mr. Griffin was doing Mr. Kane's job. He was representing the ZBA. And Venergy came in and they showed their modeling. And at the 41 hertz level, they were up at 41.4. What did Mr. Griffin suggest to Venergy they do? They put low noise trailing blades on those properties so that every one of those properties could be at 41.0 or below. Further, the sound's being measured at the wrong place. They measured 100 feet outside of, they said outside the house, really they didn't. They picked a point in the middle of the house, and they measured it 100 feet from from 4 directions from that point. That's what you can tell them. So if I got a 75-foot or 150-foot long house, I have a big house. I don't know what houses are out here. Mine's much smaller than that. But no matter what, let's say it's a 100-foot long house. And they measured to the middle of the house. They're only giving you 50 feet outside that house. because the first 50 is being taken up by that. Okay, you say, so what? Here's the problem. The IPCB regs do not allow you to measure at the middle of the house, or 50 feet outside the house, or 100 feet outside the house. The IPCB regs, and you have a memo in front of you, and I'm not going to read it all, but I wanted it in the record, and it's SLG Exhibit 3. Goes through all the cases in front of the Illinois Pollution Control Board as to where you're measuring. And it gets really complicated if you're going from a house that is part of the farm. I'm not going to go through it, but farmland's considered Class C, the home's considered Class A. The case law, I think, is relatively clear, but I've heard people think it's not clear as to where you start measuring Class A land. Is it the home itself? Is it the land between the home and the farm, where the farmland starts? I think it's that whole area you should be able to enjoy what you use as your farmstead. But I'll admit the case law isn't absolutely clear on that. What is clear is this. When you own a piece of property that is entirely residential, it's what we call Class A land. That's these 41 hertz at 41 decibels at 1,000 hertz. That's all Class A land. It's residential. And we heard it from, excuse me while I look at my notes, Mr. Christensen the other night. We heard it from Terry Wilson. Mr. Christensen owns 5 acres. Doesn't farm it, so it's completely residential. He's at 40 decibels at 1,000 hertz. Okay? So that means within, let's say, 50 feet of his house, he's at 40.5 decibels or more. We don't know what he is at the edge of his property. And that's what the law requires. What is it on your property? Because you should be able to enjoy your entire property if it's residential. I shouldn't have to say, I can't go enjoy my 5 or 7 acres because they're over the sound waves. The case law is clear. It's anywhere on the receiving property. Anywhere. Not the home, not a structure. It's anywhere on Class A residential property. They haven't given you that information. Why not? Partially because it's hard. They could do it though. All they have to do is a contour map. And I think you heard someone ask Mr. O'Neill if he'd done contour maps before. I think it might have been me. And he said yes. It's not hard. You just have to do it. Why don't they show that to you? Because they don't want you to see it. Because they know that they go over 41 and 41.5 when they do it. Let's take, for example, Miss Wilson's home. She's at 41 decibels in 1,000 hertz. Now, we don't know if that's 40.6 or 41.5. We just know they rounded it at 41. She's got 2.5 acres non-farmland. Just her and her family. The home is towards the front of the property. They need to show you that that entire piece of property is under 41 or above, 41.0. They don't. Again, it's hide the ball time. You might say, Mr. Luetkehans, why don't you go do that work? First of all, it's not our work. Second of all, that is a hugely expensive process. These people out here, they're paying way too much money for me to do it. Let alone having to hire a ton of experts to fight. That's why we have this, and that's why it's their burden of proof. Why? Because they have all these assets. They have years. They've been doing this for 10 years. They have years to prepare their testimony, years to prepare their application. And then they give you, excuse my language, this half-assed stuff. We have no idea if they're going to meet the IPCB regs at where they're at. The current location. At the current location. Okay? We don't know, because they didn't tell us. Here's what we also don't know. And this is why this 250 feet rule is so important. people I talked about, I don't remember, I'm sorry, my notes are, it's either Ms. Wilson or Mr. Christensen. They were at 2,100 feet, or 2,200 feet, and with Mr. Christensen. And he's already at 40 point something. They now want to move that turbine possibly 200 feet, 50 feet, 200 feet, or 250 feet closer. Now they may still comply with the setback, but now they're moving the turbine 250 feet closer to residences. And they say, well, we'll just give you another study showing that we're at 41. With no ability to test it? That's why we have this process. We have a process so that there can be cross-examination. That is required under the law. The Counties Act says we have a due process rights. What does that mean? It means we have a right to present evidence and cross-examination. If you allow them willy-nilly to move these any ones they want 250 feet, that process is gone. It is gone. We're going to talk more about that 250 feet and a few other things regarding that, but you need to understand that. If they do that, that's in essence a new application, which we have absolutely every right to test and have another hearing. I don't want another hearing. I don't want these people to have to pay me to come down here again. You cannot do it. Further, this standard, we're still on standard 1, deals with the health, safety, and welfare of the public. Here's what we know when we test their argument that they're being such wonderful people for coming in under 50 dBA. Nighttime now is 25 dBA. 25. There's a formula, I don't know what it is, but I can promise you that 25 and 50, that's not doubling, it's something like quadrupling or something. Some of the people asked about it. It's in the record. But it's not a doubling of the noise. It's much greater than that. The best experts in the field, and those who have represented both sides, wind developers and non-wind developers, most well known is Dr. Schoen. You've heard about him at your last hearing, you heard about him here. But if you look at, and I know you probably don't have it in front of you, so I'll quote it real quickly. SLG Exhibit 6. SLG Exhibit 6 is a paper by 4 of the most well-renowned acoustician noise experts in this field. People who are independent who test. This was a paper written by them, not someone like Mr. O'Neill who is paid to testify tonight or this week. And they each came up with their own maximum dBA limits. Kessler, 40 dBA is a design goal. 45 dBA maximum. Leventhal, 40 dBA. Schomer, 35 to 39 dBA. And Walker, 45 dBA. I won't count how many of those properties are over even 45, but there's a number. You go, okay, well that doesn't, what does that matter? 50 is our limit. It matters because health, safety, and welfare is not based on a numeric limit. You have testimony that tells you that this is not safe. You have evidence that the top experts in the field, this is not safe. Here's something else that's in the IPCB regs and in the memo I gave you. The IPCB regs are not based on just numeric limits. They are based on not improperly affecting people. And now, let me grab it. Section 24 of the Illinois Environmental Protection Act provides, no person shall emit beyond the boundaries of his property any noise that unreasonably interferes with the enjoyment of life or with any lawful business or activity so as to violate any regulation or standard adopted by the board under this act. And the board goes out and adopts a regulation saying No person shall cause or allow the emission of sound beyond the boundaries of his property, as defined in section 25 of the IDPA, so as to cause noise pollution in Illinois or to violate any provision of this chapter. If they affect health, safety, and welfare, or they affect people's sleep, which is what that article talks about, that paper talks about, they have violated that section of the Illinois Pollution Control Board regulations. Further, as Mr. O'Neill admitted, we have no idea, none, if they meet the DeWitt, well, I almost said DeWitt, sorry. The DeWitt County standards or the IPCE standards at the substation, at the switching yards, or the concrete batching plant. You could say, well, maybe that's not an issue. You know, they're just not that loud. I mean, I represent contractors. They have asphalt plants, they have batch plants. They'll tell me, oh, they're just not that loud. The problem is, somebody must have thought they were loud, because as we looked at Mr. O'Neill's resume, someone had hired him to do noise testing at concrete batch plants. But we didn't get him out for that. We have no idea. Again, it's their burden of proof, not mine. They haven't met it, they haven't shown you anything in that regard. Then we have infrasound. There's been no modeling for infrasound. They pretty much said, we know it's there, we don't know how much, so we have no way of knowing if it will or will not affect people. This is not the evidence of someone concerned about the health, safety, and welfare of their residents. In fact, what we never saw, and I've seen this in other, at least attempted in other hearings, I've never heard anybody come in and say there is no effect on health, safety, and welfare by these. Why not? Well, I can guess. There's a bunch of studies out there that says it is. They didn't want to be cross-examined on it. You heard Ms. Shipley talk about some of those. I'm not going to go through them again. You heard Mr. Waddell's testimony. I know that got complicated. I've heard it 4 times, and I'm not sure I completely understand all of it. But I'll tell you what I do know. First of all, the burden of proof is on the applicant. Here's what we also know for sure. The feds did not change the mitigation zone when the heights changed. Whether that was an oversight or not, who knows? Big entity, big agency with a lot of problems going on right now, obviously. What we know now is that 33% of the wind turbines, 33%, are now in the mitigation zone, defined as the potential for moderate to high impact, and have the risk to affect the ability to predict immediately whether a tornado is coming in this area if it forms at the wrong place and time. Is it likely? I'll be honest, I don't know. But what I do know is if there's any chance that there could be human life affected or at risk, we can't have that. No amount of money, no amount of industry is worth that. You could say, well, you know, people die in jobs. People get hurt, people die in jobs. I represent a water commission. Unfortunately, someone died 2 weeks ago. He was on a road, sign busted, came down, killed him. He decided to take that risk as part of his job. I mean, his family, I feel unbelievably sorry. It's been an awful 2 weeks. But these people out here, they haven't asked for that risk. We do not have any assurance that this will not affect the Lincoln dot radar and affect the health, safety, and welfare of the citizens of Dewitt County. We heard Mr. Keller testify. He calculated the projectile throw to be 3,440 feet to 5,430. And he confirmed by looking at the historical reports and literature. Closest homes here, half that distance, 2,000 feet. I don't know if he's right or not. I know it's in the testimony. I know that's the only evidence you have, because they didn't give you any evidence of throws, of how far a projectile can throw. They didn't give you any of that. The only evidence in this hearing is what Mr. Keller said. Almost done with section 1, and the rest I promise are much shorter, but, and I'll mess up this name. You heard this, I told before, and her husband testify about their children. You've heard other people testify about cochlear implants, epilepsy, migraines, and how these affect those things. We have heard no testimony from the applicant that they're not going to be affected. Not one iota of evidence. We cannot allow these industrial behemoths to affect people's health, safety, and welfare, and they have not met that burden. Standard 2, will not injure use and enjoyment of property, will not diminish property values. Mr. Griffin discussed shadow flicker and the and brought Mr. Marusin. Let's start with shadow flicker. Here's what we heard on shadow flicker. We are over the 30-hour per year shadow flicker limits that everyone agrees should be at most a maximum. I'm not disputing 30 hours, at least as we sit here. We don't know, here we go on to say, we don't know how we're going to fix, but we're going to fix it somehow. There's no plan as to how we're going to test. There's no plan as to who we're going to fix. The complaint process is some process that could or could not come up with anything. And it's going to take a while. In the meantime, these people have to live in it. They should know how many hours of shadow flicker, and they should know how they're going to fix it. So if we give them the permit, they then decide, well, we're going to fix the shadow flicker by doing X. I don't care what it is. These people, Clems, who have 50-some hours of shadow flicker at their home, they don't have any leverage. They don't have any bargaining power. They don't have a contract. They get to say, this is how we're going to fix it. And then they get to fight with them for 4 years as to how it's fixed, whether it's fixed right or not. That's ludicrous. They know how to fix it. They know. They know where they are. They should have been spending these past 6 months saying, here's what we're going to do to fix it. Instead, they were in a hurry to file. They filed a premature application, and boy, did they file a premature application. We'll talk about that when we get to decommission. Just like the moving of the wind turbines 250 feet, if they did the necessary homework, we wouldn't have to worry about it. They can go out there and do their soil borings right now. They could have been doing it for the past 3 years when they put these people up or started buying contracts. It's not that expensive to do soil borings. Go out there and do a site visit. See if there's drainage tiles where those are supposed to be. They didn't do any of it. Why? Because they were in a hurry. And they're trying to hide the ball. If we knew how they were going to fix these problems, it could be tested. That's why we have this hearing. But we can't test it because it's some amorphous concept. That is not enough to know we are protecting the health, safety, and welfare of the public, as is required in a special use application. Property values. Here's what we heard. Hohen says, in that report, the LBNL study from Berkeley, there's no diminution. I gave you, it's Exhibit 14. The other day, Mr. Griffin handed you 2013 of that exhibit, or of that study. 2009 was really the basic study. 2013, they tried to fix some things, but didn't really change much in its wage results. And why I gave you this is because the 2009 study, what it says when you read it, and everybody admits that they're relying on it. And Mr. Marusin agreed to this. The study shows a 5% drop in home values. It says that wasn't, quote, statistically significant, end We heard about thousands of properties they looked at. But they can't tell us whether 5% is statistically significant? That's not a big enough drop to be statistically significant. Would be if it was my house. I know a lot of people here live on farmland, and a lot of their net worth is the farmland. But we've heard from people who live in homes without farmland. And if they're anything like me, the majority of my net worth is in that house. I have a $200,000 house and I just lost $10,000, and you're going to tell me that that's not statistically significant, or my property values haven't dropped, that I should take that $10,000 loss? And this is the big study they're going to rely upon? Mr. Marouche talked about a survey of appraisers and relied upon the fact that there are little or no appeals due to wind turbines. Do not know what it's like down here, admittedly, but I know what it's like where I am. People don't appeal residential property values. It's too hard, it's too complicated, it's too expensive. The only people that appeal are the people in buildings, industrial buildings, or office buildings that are worth millions and millions and millions of dollars. It's the only way it's worthwhile. Ed Burke, Mike Madigan, they make millions off of that. They're not doing it off of Joe Smith's house. They're doing it for Holiday Inn. They're doing it for Willis Tower. I almost said Sears Tower. But then we look at the examples that Mr. Marouche talked about as to what places where stuff was built. One was townhomes by Hartman Community College. Okay. We talked about it, and I think all of you know exactly where that is, and where that single wind turbine is. It is right on I-55. I stink at golf, but I can hit a 9 to it from I-55. It's next to 3 cell towers. It's next to a school that is open at least 16 hours a day. That's completely different than living among 67 wind turbines, whereas some of these people within 3/4 of a mile of 7 of them. His other example was someone built a valuable home next to a wind turbine. And I showed the picture to him. And those are really his 2 examples of people building next to wind turbines. When you look at that picture, and as Mr. Marouche admitted, those people built a home next to their ongoing business. They have a huge business going on there. There's 6 or 7 semi-tractors in that photo. They're not worried about the wind turbine because they're already in an industrial neighborhood, their own, that they created. We also don't know if the wind turbine's theirs, on their property. Then we had this match pair analysis, paired sales. And as Mr. Marouche said, he's absolutely right. I've used Mr. Marouche for many years. I've used Mr. Keelish for a number of years. They both did match pair sales. There's nothing inherently wrong with the way either one of them did it. They picked different properties because they wanted different answers. I don't know the answer. But here's the point. You don't know the answer either. They didn't prove the answer. And it is their burden of proof to show no diminution of property values. They failed. Failed miserably. Standard 3, will not impede development of surrounding properties. Mr. Griffin just kind of skipped over that by saying the project is compatible with ag and other permitted uses. They didn't enter one piece of evidence to this effect. Other than, I guess, Mr. Marouche's testimony, which was contradicted by Mr. Keelish. What we do know is that the body appointed to make this determination, the Regional Planning Commission, decided that it was not compatible. It's their decision. They told you it wasn't compatible. Hence, they have not met their burden of proof. They haven't showed you anything for you to rely upon. Standard 4, adequate utilities, roads, drainage, etc. That one I find really funny. I don't remember the gentleman's name, and I apologize to him and to you, but we had the drainage district gentleman come in here. I think you said he was on 2 drainage district boards. They haven't met with him. They met with him someday this week for the first time. The first time. And they want to tell you they're ready to file a permit? We don't know how they're going to handle the drainage issues. You give them this permit, and they're the big boys saying, we got a permit. We're going to end up doing this drainage. We're going to go over this drainage district whether you like it or not. Same thing with the road district. They don't have to cut the agreement yet. We're going to come up. We're going to do those. Just like we're going to fix the shadow flicker. Someday. You don't know how they're going to do it. You can't even decide whether they've messed up with the ingress and egress because they haven't given you that information. We don't have those agreements. This whole thing is premature. Standard 5, minimize traffic congestion. Again, no road district agreements. We don't know how they're going to do it. We don't have a plan. We don't have anything. Just we're going to do it. We're going to do it. Trust us. Standard 6, conforming to the applicable regulations of the district. We have discussed how they're not really conforming to the Illinois Pollution Control Board regulations. So the answer to standard 6 is no, they are not properly conforming. However, they're not conforming in an even more important regulation, your own zoning ordinance, the decommissioning section. The decommissioning section, or part of the ordinance, requires that an engineer must be approved by the county. In essence, pre-approved. Not, oh, we filed, and you let us go forward with the hearing, so you must approve. That's a heck of a burden on Ms. Sarver. It's an unfair burden. Her job is not to decide if everything in this application is met. That's why we're here for this hearing. Did they meet the application? We know for a fact they didn't meet the application process. We know that they did not pre-approve an engineer. Absolutely. That in and of itself requires that this be dismissed by law. Absolutely requires it. They wanted to say, oh, you know, we must have approved it. You let us go forward with the hearing. There is a reason for this independent engineer. Let me give you a story. Again, Livingston County, 4 years ago. The applicant's engineer estimated that there was slightly over $5 million to take down 118 wind turbines. Our engineer came in at like, I think it was 14 million. And then we had an independent contractor, a local contractor, come in at like 30 million. That's the range that's possible here. So what Livingston County did is they said, let's check that number. Because they could tell that there was stuff not included, like there was here, and we'll talk about that in a minute. What did Livingston County's third-party engineer come back with? 11.8 million. More than double. Why is that important? You say, well, in 3 years, we get to check it again. Who cares? Right? I mean, that's what I'd be saying if I'm Mr. Griffin. We get to check it again, and we can let you do it right then. Okay, so they want to give you a bond or a letter of credit or something for like $2 million. That's what they're asking for, $2 to $3 million. Let's assume, for sake of argument, that I'm writing the numbers way low, and we'll talk about that. So in 3 years comes, you hire a real engineer, someone who's not doing this in a black box for the wind companies. The county hires them. The server, the county executive, they go hire a person that's independent. Guy comes in and says, $12 million. It's going to cost us $12 million to do this. The next company, because we know it's not going to be Tradewind, says, oh, we don't have $12 million of excess capital we want to tie up. It's no longer making the kind of money it was 3 years ago. Tax credits changed, the business changed, I don't know. But as a lawyer, that's what we're here to do, is protect. So they say, guess what? You get $2 million of our dollars. We're not giving you 12, we're not giving you another 10. We're walking away. The county is now on the hook for that $10 million, or the people are, the leaseholders. Those 3 years of additional taxes, which haven't even really started to kick in at the beginning because the project's not really built for the first year and a half, that hasn't saved you $10 million enough. You haven't saved $10 million to take that over. That's why an independent engineer is so important, and that's why we're here to test that. They didn't even bring in their engineer. They didn't bother. Why? I don't know why. Because they did it in a black box, and they can't answer certain questions. We're going to take a break, or?
We're going to take a break.
Thank you. This hearing is even a greater need for that independent engineer to have been jointly hired after seeing what Tradewind tried to pull. They're playing hide and ball. How? We have a report here on a hugely important issue for the county, an issue of protection for the county. This doesn't help my clients. It doesn't stop the development, but it's indicative of what we've had to go through here. I mean, what does stop the development is the fact that they didn't hire an independent engineer. But what I'm about to say is more just protection for the county. This is here to protect the county and its residents from financial disaster and for safety reasons. As I gave you the scenario of there's not enough money to get rid of turbines. What happens to those turbines? The county doesn't have the money, they sit here and they rust for years. That's what we've seen happen in California. That's why these decommissioning have been put in place in ordinances and why they're so important. Tradewind's presented no one with any actual knowledge or experience to testify on this issue. A few minutes ago, we talked about due process rights. That is a violation of my client's due process rights. They have a right to cross-examine the witnesses. They didn't bring a witness in with any testimony, with any ability to be cross-examined on such a huge issue. And that also requires that this application be dismissed and denied. But let's proceed with the evidence that Tradewind's presented, or more importantly, what they did. The report says it's based upon someone hauling the crushed rock for free. That's crazy. As I said, one of the things I do is I represent construction companies. I have two main sources of business. One is construction companies, one is government. I don't know if any of you have any construction experience, but unfortunately I've had to try a number of cases. There is no support for that statement in their report. None. That it can be all the way for free. Why? This is used material that is only usable on a small portion of available jobs. Can't be used on public jobs after it's been in the ground. think they admitted that. Even the guy who wasn't the engineer, he admitted that. This unknown job would have to need dirty CA6. So it can't be a public job. And there's a lot of CA6 that's being put down. We don't know how much, because they don't need it to know. They don't give us the numbers. We don't know how deep it's going to be. But it is tons and tons and tons of CA6 that's going to be hauled down, put down, and then supposedly hauled away. So you have to have a job nearby to haul it to you. So what does that entail? It entails getting the guy out there to haul all this gravel, this dirty gravel. So you got someone on backhoe, you got the material, the time on the backhoe, the man hours on the backhoe, local 150, or whatever operating engineers are here. I think it's local 150 still around here, at 30-some bucks an hour. Then you got trucks sitting there that they're putting into. It's not being used for something else. Then that guy in that truck has to haul it at some union rates. Then you got the gas, the fuel, depending on how far he has to haul it to. He's got to haul it an hour, it's a 2-hour trip. He's got to haul it half, There's not that many construction projects in Dewitt County that are going to be able to take that amount of CA6, dirty CA6, all at once. They're going to have to haul that all over this darn state. They can't use it for a road project, we heard that. And they say someone's going to take it and not charge them for it because the CA6, which is worth about $2 a cubic yard, it's such great value, trust me, you cannot haul CA6 anywhere for $2 a cubic yard. You leave it in the ground on every other project. We have no idea what the costs are. It's the same thing for scrap. We saw a scrap value. No one's here to cross-examine or to testify as to what the costs are to haul that scrap. We have no idea. We're talking about hauling all that scrap somewhere. That steel. Steel's been fluctuating. One time it's 300, 3 years later, a year later it's 200. And now we're going to haul that to, let's say, Chicago. 2.5-hour round trip each way. At $200. These costs are so underestimated, and they don't have anybody here that you can actually see that. Why? Because they know they're underestimated. They didn't give you any calcs, they gave you 6 pages of a report, or 6 or 7 pages that just showed you a number. Trust us. Trust us. They haven't shown that trust me. Things that report's a joke, except it's not a laughing matter. Because to protect the citizens of this county, we need to know those costs, real costs. There are a number of other costs. We didn't get into them because they didn't have anybody here to cross-examine. But you can go through that whole report, look at it, see if there's any support for any of those numbers. You'll find them easy done. They give you a number. Scrap, no idea where you're going to haul it or what the haul costs are. Gravel, same thing. Concrete, no idea. We're breaking huge pieces of concrete down to 5 feet. We got to break it. We got to put it in a truck. We need a backhoe to do that. Then we have to haul it somewhere. And then you're going to have a tipping fee. We heard about the tipping fee, but that's all we heard. And you got to take it to a C&D site, construction and debris site. You can't just take it to anywhere. You can't take it to a landfill, you got to take it to a C&D landfill. Construction and debris landfill. I don't even know where that is. They don't know where it is. At least if they do, they sure as heck didn't tell you. Okay, let's talk about their quote, I say that, special conditions, end quote. I say that with unbelievable. I say that with, I don't even know what the word is, I'm sorry. Here's what they got. Of these 6 special conditions they recommend, and it's, the first one is they want to extend the building permit process for 3 years. They want to extend it, right? You heard Ms. Schaefer the other night talk about the ambiguity in what they're requesting. It's, we submit a building permit or a plan for the timing to commence construction. So now they've just made that 3 years, turned it into 6. If they say, well, we got a plan, but it's going to take us 3 years. There is a particular section of your zoning ordinance that says 1 year. The first 4 variations they ask for, that, the issue about producing energy for commercial sale after providing written notice, the shifting of the site plan, the shifting of the turbines, and the signage. Those are not special conditions. We're going to talk about that right now. As I said, I've been a zoning lawyer for 30 years. These are requests for variances. You say, okay, so what? What's the deal? Let me start off on that. I should have told you this earlier. When I said that the burden of proof is on the applicant to meet all the standards, that is from a case called Living Ward. It's the most important case in special uses. It's the Illinois Supreme Court. It was about a church. It was a special use. I won't go into the details, but Living Word is kind of the Bible of special use cases. From 2001, the site is City of Chicago Heights versus Living Word, 196 Illinois 2nd 1 from 2001. A special use is a type of property use that is permitted within the zoning district by the controlling zoning ordinance, as long as it meets the conditions. That's what Living Word says. It meets the conditions. And then it goes on to say that it's their burden of proof. Special uses are clearly distinguished from variations. Quote, a variance is authority extended to a property owner to use his property in a manner forbidden by the zoning enactment. End quote. Generally upon showing of hardship. That's from Living Word, as well as Illinois Statutes 55 ILCS 5/5-12009, and also cited in Sinclair, which is another Supreme Court case. The Dewitt County zoning ordinance expressly requires a showing of hardship. Under your ordinance, you want a variation, you have to show hardship. Another thing they have to do is they have to apply for it. They didn't apply for a variation. There's no notice for a variation, which is required under the statute. Ms. Sarver, once she sees a variation, she puts out a different notice than she does for a special use. The notice says they're requesting the following variations. That's the only way you can grant them a variation. Trust me, we're going to talk about it. These first 4 are clearly variations. What's the difference between a special condition and a variation? Special condition is something that the county puts on a special use to restrict it because it needs to make sure that we're protecting the health, safety, and welfare. So a special condition is a restriction on a special use. That's the case law, and the cite to that is Halfway House for City of Waukegan, 267 Illap 3rd, 112 at 116, 2nd District case from 1994. That is basic zoning law. It's a restriction. What's a variation? Variation is the opposite. Variation is I'm in front of you and requesting something different, something more lenient than the zoning ordinance. These are clearly requests for leniency or exceptions to the zoning ordinance. Zoning ordinance says, give us a spot. They say, oh no, we want 250 feet anyway. That's a variation. They're not wanting to follow your ordinance. They're looking for something different, something that benefits them, not benefits you. Same thing with this 1-year permit. You're going to start construction within a year, I think is what it says. They want 3 years, and then they want all these other things, which can make it unlimited. That's not a special condition. That's them requesting relief from your ordinance. And when you request relief from your ordinance, that is a variation. The Sinclair Pipeline case, 19 Illinois 2nd at 373, another Supreme Court case, specifically says that. That's a variation. That's the definition of a variation. They requested 4 variations. Didn't notice them up, didn't ask you, but oh, we just want you to call them a special condition. They got it backwards. Why didn't they ask for a variation? Could have just done it. County board, if they want to grant this permit, they could ask for it. But they could do it, right? Here's the difference. Your ordinance requires a showing of hardship, as does pretty much every zoning ordinance in the state of Illinois. Well, what's the hardship? They don't have a showing of hardship. They haven't shown hardship. There's no hardship for having to move turbines 250 feet. What's the hardship? We didn't want to go do our homework. It's like the 6th grader that I had. My daughter. I didn't want to do my homework. That's not hardship. That's I was too lazy to do it. Or I was in a hurry trying to make too much money. You have to show a hardship. What's the hardship between taking it from 1 year to 3 year? Oh, we don't know. I can come up with some reasons that they could argue, but they didn't. It's not in the evidence. The hardship, again, is we're not ready. They should have filed this application when they were ready. But they didn't. These conditions do not restrict the project. They give it leniency. And they do not provide protection from health, safety, and welfare. They provide protection, not to the health, safety, and welfare of these people. They provide protection to Tradewind's money. That's absolutely improper. Let me ask you, let's talk about this. Moving the turbines. Let me ask you a question. If I was to say to you, and it's rhetorical, I'm not going to answer, but if I was going to put up a barn, here, you guys, I'm sure, have done way too many hearings on barns, shed, and I want to put it in the setback. 2 things. One, you're going to find out exactly how close that is to the neighboring property, right? You're going to say, the ordinance requires you to be 30 feet away from the neighbor. So we want to know exactly how far if you're asking for relief. So if you're going to be at 28 feet, it's a lot different than if you're going to be at 5 feet. And would you call that a special condition? No, you call that a variation. You see those every day. I don't know how often you meet, so I shouldn't say that. But you see those, I'm sure, annually. Someone needs relief from the zoning ordinance. Ms. Sarver puts that out as a variation. You listen to it based on a variation standard, which is a completely different standard than a special use. And it doesn't have some of the presumptions that special use has. In conclusion, I know you're all really happy to hear that. I have used the word test a lot tonight. Why? Because this process that you've put up with and been very attentive, probably more than I could, is meant to test the application and the basis of the applicant's proposal and arguments. When we go through the process, we're able to test the applicant's general statements, those statements that Mr. Griffin made at the beginning that seem so easy. When you test them, they're not. And that's why they have to give specifics, so we can test those statements. Such as, we want to move the wind turbines 250 feet, but we will fix the shadow flicker problem later. Those are so improper in this process. Or, trust us, just fix the shadow flicker process, shadow flicker problem. Or trust us on the decommissioning costs. Even though there is no one here to support them and you have no idea how we came up with the numbers, or how we're going to fix the shadow flicker problem, or what the sound's going to be in any of these homes after we move these turbines 250 feet. You may say, oh, we move one turbine 250 feet, how can it change much? They're on the edge. But they're not asking to be able to move one turbine. They have 67 turbines they're asking to have the absolute leeway to move. These turbines affect each other on noise. You move one. It's not just noise from one turbine, it's noise from the number of turbines and how they interact with each other. The application is premature and not able to be fully vetted by you, by us, by the county, because there is nothing but unknowns. For that reason alone, it has to be denied. However, on the other hand, even the facts we do know do not support the granting of the application, because as we've just gone over, Tradewind has failed to meet its burden of proof on those 6 standards. They haven't even come close. Not even close. 2 or 3 of them didn't even try. Not only did they fail to meet the requirements of your ordinance, they failed to meet the requirements of what we call the LaSalle factors, which are what your ordinance is based upon. And not only do they have to meet, that is, under Illinois law, what they have to meet if they want a special use, the LaSalle factors. So it's not just your ordinance, oh, we can waive our ordinance. You cannot waive the LaSalle factors under Illinois law. The failure to meet the burden of proof, the failure to complete a proper application, the failure to provide you a decommissioning report by an independent engineer, the failure to meet the 6 standards, the failure to protect the health, safety, and welfare of these people, or show that they're protected, because they haven't shown it. That requires that this special use application be denied strongly. You have no choice under the law. Thank you very much for your time, and thank you for putting up.
We have any questions from the board? Do you have any questions from the audience?
Thank you.
If not, thank you.